Before we start with the tutorial, we would love to hear your views about today's topic or our tutorials in general. We appreciate the impact we have on your studies, and we wish to learn how we can improve our tutorials for you. Introduction to Law 202 Presence, Civil Procedures, Rules of Court, Access to Justice and Social Justice in Rules of Court. There is no doubt that applicants/plaintiffs become so anxious to prosecute their applications or actions and recover their claims that they allege are due to them from respondents/defendants. This is part and parcel of the right to access to courts in terms of Section 34 of the Constitution. The right guarantees everyone their right to have any dispute that can be resolved by the application of law decided in a fair public hearing before a court. To achieve this, however, in circumstances where the respondent is an unsophisticated lay litigant, its approach ought to be facilitative and not obstructive. The justice system battles to maintain veracity because the layperson cannot fathom the delays and the astronomical cost that makes access to justice unreachable. Since parties have to defend court processes against them and are mostly unsophisticated with very little knowledge of the rules of civil procedure, much less the rules of court, the legal intensity will vary according to the interest to be served and the fallout of improper litigation. Unintended consequences from rules of court to the idea of access to justice and social justice. Strict and formal rules of court brings opportunity for unscrupulous litigants and those who would wish to delay or deny justice to so manipulate the court's procedures that their true purpose is frustrated. Courts are ever vigilant against this and other types of abuse. What is more important is that the court's officers, and especially legal practitioners, have an equally sacred duty. They owe an overriding and paramount duty to the administration of justice to court. Lawyers conducting litigation hold a divided loyalty. They have a duty to their clients, but they may not win by whatever means. They also owe a duty to the court and the administration of justice. Nothing less is expected of them, and if they do not measure up, a court will mark its disapproval either by an appropriate order as to costs against a defaulting practitioner or, in a proper case, by referring the matter to law society for disciplinary action. Civil Procedure and the South African Constitution. Section 34 of the Constitution guarantees a litigant's right of access to court for purposes of resolving a dispute. This right is an embodiment of an ancient common law principle that a person has a right to a proper and fair hearing, which has, at its core, the right to a litigant to tell his or her side before an impartial presiding officer, albeit that this right is subject to limitation. It is for this reason that our rules of civil procedure exist. These rules are, to a large extent, codified in the uniform rules of court, which govern the manner in which proceedings take place, so that every litigant's rights to a fair trial may be realized. Court rules should not be observed for their own sake, where the interests of justice so dictate. Courts may depart from a strict observance of the rules, that, even where one of the litigants is insistent that there be adherence to the rules. Courts have often said that it is trite that the rules exist for courts and not the courts for the rules. Under our constitutional dispensation, the object of court rules is twofold. The first is to ensure a fair trial or hearing. The second is to secure the inexpensive and expeditious completion of litigation and to further the administration of justice. The proper administration of justice and the concept of interest of justice, as is emerging in our constitutional jurisprudence, are synonymous in that they both have the purpose, proper and fair resolution of disputes between litigants. An attempt to stymie the formulation and ventilation of the dispute between the parties would run contrary to the proper administration of justice and would not be in the interest of justice. Core principle for rules of court. The rules of court are designed to secure the inexpensive and expeditious completion of litigation, that the rules of court must not be abused, particularly through the making of unnecessary procedurally related applications that prevent the speedy resolution of litigation, or are used for an undue or ulterior purpose, or where the upholding of an objection to a technical defect would only result in a pointless waste of time, or costs would result in the highly unsatisfactory result that the parties to proceedings will be required to commence them de novo and on the same facts. On this end, you notice that the rules of court are invoked to prevent, stymie, or obfuscate the true issues. The court should not permit such conduct. Functions of rules of court. The proper function of court is to try disputes between litigants who have real grievances and so see to it that justice is done. The rules of civil procedure exist in order to enable courts to perform this duty with which, in turn, the orderly functioning, and indeed the very existence, of society is inextricably interwoven. The rules of court are in a sense merely a refinement of the general rules of civil procedure. They are designed not only to allow litigants to come to grips as expeditiously and as inexpensively as possible with the real issues between them, but also to ensure that the courts dispense justice uniformly and fairly, and that the true issues which I have mentioned are clarified and tried in a just manner. The rules of court, like any set of rules, cannot in their very nature provide for every procedural situation that arises. They are not exhaustive and, moreover, are sometimes not appropriate to specific cases. Purpose for rules of court. The purpose of court rules is to regulate the litigation process, procedures, and exchange of pleadings. The entire process of litigation has to be driven according to the rules. The rules set the parameters within the course of litigation has to proceed. The rules of engagement must, therefore, be obeyed by the litigants. However, dogmatically rigid adherence to the uniform court rules is as distasteful as their flagrant disregard or violation. Dogmatic adherence, just like flagrant violation, defeats the purpose for which the court rules were made. The prime purpose of the court rules is to oil the wheels of justice in order to expedite the resolution of disputes. Quibbling about trivial deviations from the court rules retards instead of enhancing the civil justice system. The court rules are not an end in themselves. This takes us to our next topic: remedies to noncompliance to rules of court. A court employs a test for determining whether condonation should be granted or refused if there are or no interests of justice when a litigant is noncompliant with rules of court. The factors that are taken into account in that inquiry include the length of the delay. Without a reasonable and acceptable explanation for the delay, the prospect of success are immaterial, and without good prospect of success, no matter how good the explanation for the delay, an application for condonation could be refused. The explanation for or cause for the delay. Parties are encouraged to not be reliant on their own processes and ignore the court. The prospect of success for the party seeking condonation. Where there is a flagrant or gross failure to comply with the rules of court, condonation may be refused without considering the prospect of success. The importance of the issues that the matter raises. The matter could be vexatious or moot, which may not warrant further adjudication. The prejudice to the other party or parties. And the effect of the delay on the administration of justice. The delay may affect justice and pollute the sanctimony of the rule of law. Prejudice and the interest of justice are vital. Application of rules of court. The rules are to be applied sensibly and pragmatically to bring about the ultimate ventilation of the true issues between the parties. The rules act as anchors in the tides of injustice, to keep the principles of law afloat. Our civil procedure reflects a progressive movement away from rigid formalism and slavish adherence to a codification that is intended to be facilitative and not obstructive, which has become entrenched in our law by the constitutional right of access to court. It must be remembered that the formalistic approach of applicants comes at a great cost to bringing the matter to finality. The formalistic approach of the applicant will continue to involve the parties in much expense. Compliance with court rules and absence of prejudice. In the absence of prejudice, rigid adherence to the rules of court is a catalyst for delay and further costs. It is expected, even in absence of prejudice, there may be resistance. It follows that resistance to the rigid adherence to the rules of court where no real prejudice ensues is not new in South African civil procedural practice. In the absence of prejudice, interfere with the expeditious and, if possible, inexpensive decision of cases on their real merits are permitted. Interest of justice in noncompliance with rules of court. The introduction of considerations of the interest of justice broadens the court's discretionary powers to prevent unnecessary delays and concomitant and unnecessary incurrence of legal costs at the one end of the scale, or the deprivation of a legal remedy at the other end of the scale. Reflecting on the principles discussed on this tutorial, we will look at the key lessons from the tutorial. It is important that it is expected of legal practitioners to familiarize themselves with the relevant rules of court. The uniform rules seek to regulate procedure, form, and not substance. Once a notice of set down is served, technical procedural noncompliances are dealt with in court and not unilaterally by a party deciding to ignore the notice of set down because of some or other procedural shortcomings. If a court satisfies itself that the proceeding or step is irregular or improper, following its conclusion that a step or proceeding is irregular or improper, a court, however, will make an order that it deems fit to remedy noncompliance. One of the important lessons which every legal practitioner should carry with pride is to adhere to the rules of court and to properly advise clients when they litigate with lay opposing litigants. This part ends our session for the day. We will discuss criminal law on our next topic, on bail and its legal relevance in criminal procedures. Thank you for tuning in.